Harvard Divinity School.
Psychedelic Spirituality and the Underground 1, February 17th, 2024.
Thank you, everyone, for joining us this afternoon.
We can talk later.
Yeah. I'd like to welcome you to the Psychedelics and Spirituality and the Underground #1 panel that will explore the varied landscapes of entheogenic practices and their spiritual significances. Today, our distinguished panelists will share their insights on plant medicine and psychedelic spiritualities, encompassing historical roots, legal challenges, and cultural manifestations of entheogenic religious groups. Please hold your questions until after the final presentation has ended. I'd now like to welcome our first panelist, Allison Hoots, who is the principal attorney at Hoots Law Practice and president of the Sacred Plant Alliance. Please welcome Allison.
Hi, everyone. Good afternoon. Because I'm a lawyer, I have a disclaimer. I am not giving you legal advice, and you are not my client. So I do a variety of things. In my legal practice, I work with what I call the full spectrum of practitioners, from ketamine practitioners to trip sitters, which I like to call risk reduction service providers, and churches. And what's interesting, I just would like to note, is how each of these practitioners often talk about the spiritual aspects of the services that they provide. But today I'm talking about religious use and the law and the exemption under it, and how that's defined and applied. So, First Amendment protects religious beliefs and its exercise. How that's evaluated in the court system, in particular, in context of government and the ways that they burden beliefs and exercise, there's a standard of review. So there are 3 types, the first being rational basis, the second being intermediate scrutiny, and the third being strict scrutiny. And strict scrutiny is mostly applied when it affects a guaranteed right under the law and a fundamental right. So the problem was that in 1990, there was a case where the Supreme Court decided that they weren't going to apply strict scrutiny because that the law that was burdening religious exercise was generally applicable, meaning it didn't directly discriminate against a particular religion. And so what's interesting is that case was individuals who had been using peyote in a ritualistic ceremony and therefore were denied their employee benefits, unemployment benefits. So in response to that case, in one of the most bipartisan acts in government, there was new legislation introduced and passed in 1993 called the Religious Freedom Restoration Act. And what it did was it said, even if a law is generally applicable, you have to use the strict scrutiny test. So this was pretty important. For example, the Controlled Substances Act is generally applicable. So you can see here I have a definition of what is the strict scrutiny test, and that is that government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, except when the law is in furtherance of a compelling government interest and is the least restrictive means of doing so. So, as I said, Controlled Substances Act is very clearly generally applicable. They're saying everyone cannot use these substances in these certain ways unless, we have the right licensure, it's prescribed, etc. But if you look at the way RFRA was enacted, it was specifically designed to protect the ability of the religious minorities to practice their faiths. So this talks a little bit about the shifting of burdens under RFRA, the analysis of RFRA. And so first, the claimant or the person raising an affirmative defense, meaning, yes, I violated, in this context, the Controlled Substances Act, but I have a reason for doing so that is defensible. They have to establish there was a substantial burden, that their exercise was religious and it was sincere. The burden then shifts to the government to demonstrate that their government interests are compelling enough that we should burden that exercise and that there aren't less restrictive means to do so. So here what we're really assessing is whether the government, whether the exemption frustrates government interests by causing harm. So there's a very long, complicated analysis among all of the circuit courts in trying to figure out how you determine what a substantial burden on religious exercise is. I'm not going to get too into it because it's really complicated, but mainly there are two ways of analyzing it. The minority view is the centrality analysis, which says that the religious exercise in violation of the law has to be central to the religious beliefs of the individual or community. They often refer to it as they must be religiously compelled, versus the minority or the majority view, which is that it just has to be religiously motivated, but not compelled. Interestingly, though, there's been some inconsistencies. So in some circuits where they were using the majority view, when it came to a psychedelic, they actually referred to the minority view of centrality. So, with the stigma of psychedelics, the court may kind of do its own thing, as we see. So what's really obviously very interesting is how the courts have defined religion, right? Because once you've established there's a burden, then is the belief religious? Early days, there had to be God, right? That was what religion was. There was a God. And then it shifted over time. And one of the more relevant cases now is Yoder, which was 1972. And the analysis there that they used was the compelling interest analysis, which ultimately became the strict scrutiny test required by RFRA. But they defined religion as deep religious conviction shared by an organized group and intimately related to daily living. And what they highlighted there was that there was an organized community and that it permeated their everyday existence. So later there was another case, and this was the Myers case. This one is used a little more now, and I think it's a little broader. And they said, it has to be a religious belief, and that is when there are ultimate ideas, metaphysical beliefs, moral or ethical systems, a comprehensiveness of beliefs, and accoutrement of religion, which I just love saying that word. But I'm going to explain why I find that problematic in a moment. Not the word, but that factor. But ultimately, not one of the factors are dispositive. So if minimally satisfied, if there's enough of some of it, they would say, okay, we can conclude that this was religion. So that's the Myers test. Another interesting definition of religion is what comes from how the IRS defines a church. As you can see, there are many, many criteria here, but again, distinct legal existence is an interesting one, that there's a corporation, a nonprofit corporation, recognized creed and form of worship, definite and distinct ecclesiastical government, religious history, membership not associated with another church or denomination, ministers, its own literature, regular congregation, regular services. And I highlighted regular congregations because if you apply to be a church, to be recognized by the IRS, which, to note, there is actually an exemption in the Internal Revenue Code that says that if you are a church, you don't have to be recognized by the IRS to operate and receive the benefits of a nonprofit entity. But the form says that if you say you're a church and you don't have a congregation or a religious membership group, then you're probably just a religious organization and not a church. I find that problematic. I'll explain why. So the IRS does look to a totality of this information, not like one concrete definition. For example, the Satanic Church was recognized in 2019. They are non-theistic. But one issue is that an Internal Revenue Code 501c3 nonprofit, like a church, is not allowed to engage in illegal conduct or conduct contrary to public policy. For example, in 2021, a church called Ayahuasca Church of Healing was denied their tax-exempt status when they applied because they said they had an illegal purpose and the distribution of controlled substances is illegal. This is being appealed, and I actually filed an amicus brief about this, which, if you'd like to read it, you can get that online. It's pretty interesting, I think. Biased. But one question I raise in that amicus brief, and one thing I want us to think about, is a public policy RFRA and the guaranteed right to religious exercise. And so can a 501c3, although engaged in, quote, illegal activity, actually be consistent with public policy? DEA has also provided a definition of religion in response to one of the cases where an exemption was granted to a court to use ayahuasca, which I will talk about in a moment. They created an exemption application guideline where you petition for the exemption. It is not a rule, which is something else I argue about in that amicus brief that you should read. But in this petition guidelines, they say they look at the religious manifesto, whether the participants have professed religious beliefs, whether it's purely religious or just more therapy, self-help. Are there commercial benefits as opposed to not-for-profit religious purposes? And the ease of access to the sacrament, which they are saying basically is a circumvention of the law. So what courts like to say is what is not a religion, because it's so hard to define. Standards on matters of conduct, just philosophy or way of life, personal, political, ideological, secular beliefs, which include communism, veganism, utilitarianism or nihilism, a lack of organized community or congregation, and lack of ceremony, which I will discuss in a moment. In 2014, there was a Hobby Lobby case. I don't know if anyone heard about that one, but a closely held for-profit entity that was made up of a family that had Christian beliefs applied for an exemption under RFRA, and in that analysis, they were granted the exemption. And the Supreme Court said, it is not for us to say that their religious beliefs are mistaken or insubstantial. Instead, our narrow function in this context is to determine whether the line drawn reflects an honest conviction. So here the courts are saying we can't really say what's religious But instead, we're going to look at sincerity, which we know is the next step in the strict scrutiny analysis. So what is sincerity? I mean, that's a fact-based. Someone has once said it's a sniff test. So in one case, which is Quaintance, the 10th Circuit did identify 5 circumstances that would identify when they're insincere. And ad hoc beliefs, which is like, oh, just now I have these beliefs because it helps me get around the law. The quantity of the controlled substance. So if you have more substance than you could possibly use within your religious community, maybe that's not what it is, a religious community. Evidence of commerce, lack of ceremony, and other illegal substances. In one example, there was a community that was using marijuana. They claimed it was sincere religious use. Sorry, 2 minutes? Oh. Did you say 2 minutes? Okay. And because they were also buying cocaine from the same person, they said, well, this doesn't look very religious. Oh man, I'm running out of time so fast. So basically, there were 2 cases where they were granted an exemption. In 2006, this was the US Supreme Court. I'm not going to get too into it because I'm running out of time. There was another in 2009. That was the 9th Circuit case. But what I want to point out is in Ocentro, they said that the reason RFRA was enacted was in response to the denial to use the sacramental, to engage in the sacramental use of a controlled substance. So the problem here is we're seeing a lot of courts conceding it's religion if there's Judeo-Christian concepts. We can see that the accoutrement of religion is based on long-standing religious beliefs and practices. So in this way, where they're defining religion, there is a seeming preference for a particular type of religion that has a particular type of practices and particular types of hierarchies. So, is that actually accomplishing what they're meant to do, protect the religious minority? I could talk a little more about, how you minimize the government interests in enforcing the Controlled Substances Act, but I think that's something I have to just skip over. But another issue here is, when does spirituality become religion? Because what they've said is religion is finding sufficiency in where the believer's own scheme of things, it is religious. And it expands it very broadly. And we don't really know what to do with that. Like, what is the impact of that? What exemptions are going to be permitted? Of course, there's a balancing test, right? But, where is the bright line? So certain things that are concerning is, this requirement of congregation. In modern life, there is less community. Some people meet on Zoom, and maybe that's their community. Maybe having a ceremony, a couple times a year is what a congregation is. A lot of communities do not have a leader in these groups. So how do you identify hierarchy? And religious texts, in the SoulQuest petition, which I think someone else is going to talk about, the DEA said, the participants had never even heard of the religious text that the community said was like their text. And it's important to note that courts do protect the convert, the one who has now had a more recent change in their religious beliefs. And, there are people who want to shop around. Maybe you want to go sit with one community who uses a controlled substance and see what it's like, and then have to go try another community. And that's very common in non-sacramental church contexts. But here it may demonstrate a lack of religion. So it's important to figure out how to use language that the government will understand without compromising your religious beliefs and and your sincerity, and also begin to realize, how can we expand appropriately the definition of religion? So this was basically what I was saying. Is the RFRA criteria and religion, is it outdated? And does it illegally prefer one type of religion over another? So I think I ran out of time significantly. Thank you.
Thank you, Allison, for that elucidating presentation. I'd next like to welcome Brad Stoddard of McDaniel College to the Psychedelic Spirituality panel. He'll be presenting on curating the entheogenic underground. Welcome, Brad.
Thank you. Two things. First, I apologize that I do not have a PowerPoint. Second, I could summarize my paper by basically saying what Allison just said. We overlap a lot, so I promise I didn't plagiarize your paper. The revolution in American religiosity may not be televised, but it is happening nonetheless. Entheogenic research suggests, ethnographic research suggests that every night Americans across the country gather to commune with their creators, to interact with their ancestors, to enter what they consider the spirit world, to gain supernatural insights, and to engage in what they otherwise deem as religious or spiritual experiences. In this regards, their actions do not seem particularly revolutionary or novel. What distinguishes these people is not their desire to have religious experience, rather the means they employ to occasion these experiences. Specifically, their rituals and ceremonies involve the consumption of what are commonly called psychedelics or illegal drugs, substances they increasingly call entheogens. In other words, because their religions involve the use of illegal substances, these people are confined to what scholars have routinely called the underground. These same scholars often theorize the underground as the sociocultural, political, or economic spaces that exist outside the purview of the state. This paper argues the opposite, as it demonstrates that the state is the primary curator of the entheogenic underground, specifically as it relates to the growing world of psychedelic or entheogenic religion. To understand this point, we begin by recognizing that entheogenic churches or communities are increasingly common in the United States and beyond, and that these communities have various forms or organizational structures. Some of these communities are more informal and operate with a rotating slate of attendees who gather to consume any number of substances under the guidance of what I have elsewhere described as contract facilitators. In exchange for compensation, contract facilitators can serve any number of substances, legal or otherwise, without any expectation of returning clientele. In addition to informal groups administered by contract facilitators, some communities have comparably stable rosters of participants who meet regularly or semi-regularly to consume a particular or various substances, depending on the provider, the availability of the substance, and the interest in the particular substance being served. I have described one such community elsewhere that meets in Maryland. The members of this group routinely meet at a particular house where they consume a rotating list of substances. This group doesn't have a formal leader or a roster of members. Instead, a rotating group of people attend. On any particular ceremony, a core dozen or so attend, with roughly a dozen more rotating in and out, depending on the substance. This group, along with similar groups, are different from groups organized around contract facilitators, as they have a stronger sense of community in a core group of attendees. They resemble each other, however, in their desire to avoid the church model of consumption and the resulting paper trail that results from this model. For people who embrace these more informal models, the looming threat of prohibition motivates these facilitators and consumers to forego the church model, to remain anonymous. Some people, however, file the paperwork to create formal churches premised on the consumption of otherwise illegal substances. Some of these people research the process and complete and file the paperwork themselves. Other people hire attorneys who specialize in the emerging field of entheogenic law. You just became Data.
I waved, yeah.
In this small but growing field, 3 attorneys, 2 of which I'm going to talk about, Greg Lake and Ian Benoist, Allison is the third, have emerged as influential, joking aside, in this small but growing field, 2 attorneys, Greg Lake and Ian Benoist, have emerged as influential attorneys. They have appeared on numerous podcasts. They have started their own church, and they have helped help people file the paperwork to form 70 entheogenic churches, and they've assisted dozens more. Lake himself even wrote 2 books on the topic titled The Law of Entheogenic Churches, Volumes 1 and 2. Lake and Benoist believe that entheogens should be legal and available for anyone who wants to consume them medicinally or sacramentally. They recognize, however, that entheogens are still illegal, but that in 2 court cases, the courts have concluded that specific groups can legally import and or consume illegal psychoactive substances. As Lake describes in one of his books, these cases are important because they potentially provide precedent for other and newer entheogenic communities to consume entheogens without fear of state intervention, provided entheogenic founders replicate the models of religiosity the courts have previously approved. The first of these cases is Gonzalez versus the UDV, a case concerning ayahuasca, or what the UDV calls huasca. To understand this case, consider that in 1999, US Customs agents seized 2 shipments of ayahuasca. One was destined for the UDV in New Mexico, and the other was being shipped to a Santo Daime community in Oregon. These 2 groups share much in common. They were both founded by rubber tappers in the 1900s, and both of these groups came to the United States in the late 1980s or early 1990s. Today, as journalist Don Lattin described, interest in ayahuasca is modestly common and growing. That was not the case, however, in 1999, when very few Americans were familiar with ayahuasca, including the US Customs agents who seized the shipments. Customs agents tested the liquids and found that they contained DMT, an illegal substance classified as a Schedule I drug under the Controlled Substances Act. They subsequently executed search warrants on the founders of both communities. They seized roughly 30 gallons of ayahuasca from Jeffrey Bronfman, the founder of the UDV in New Mexico, and arrested Jonathan Goldman, the leader of the Santo Daime community in Oregon. Bronfman, however, fought back. He hired attorneys who represented him and his community, resulting in the aforementioned case, Gonzalez versus the UDV. This case made its way to the Supreme Court. In the public hearing and in subsequent decision, neither the government nor the justices indicated that they doubted the religious sincerity of the UDV. Instead, as articulated in the court's opinion, the government was concerned with 3 primary issues: protecting UDV members' health and safety, preventing the diversion of ayahuasca, and complying with the United Nations Convention. The court rejected each of the government's arguments and, citing the Religious Freedom Restoration Act, concluded unanimously that the UDV is exempt from the generally applicable prohibition on importing and consuming ayahuasca. Based on the Gonzalez decision, Jonathan Goldman and the Santo Daime community in Oregon filed their lawsuit. The District Court of Oregon decided the case where the court accepted the group's religiosity and religious sincerity. Again, they didn't question it per se. Based on this perception, combined with the unanimous verdict in the UDV case, District Judge Panner concluded that Santo Daime deserved a similar exemption to import and consume their sacrament. Returning to Greg Lake, the attorney I mentioned earlier, he addresses these cases at length in his book, as he contends that these cases provide the clearest legal precedent for subsequent communities to receive similar exemptions. He does, however, acknowledge these cases' limitations. That is, Lake looks to these cases to provide a legal framework for more entheogenic communities to consume ayahuasca and other entheogenic sacraments, predicated on the sincerity of the user's religious beliefs. As he sees it, though, the problem, however, is that the courts accepted at face value the group's religiosity and instead adjudicated these other 3 issues. Lake concludes that these cases give clues to help his clients demonstrate religious sincerity, but he wants more than clues, he wants precedent. He claims to find that precedent in several decisions from the 1900s. Lake explores the case law and identifies 2 court cases that address the legal definition of religion. He writes, while there is no bright line test to determine what makes a belief or practice religious, the federal courts have created a couple different tests to gauge religious sincerity. The first that he cites is the U.S. v. Myers, a 1995 case. According to Lake, in Myers, the district court conducted an exhaustive review of prior case law to create a list of the relevant factors that have been considered by the courts in determining what constitutes a religion. Lake summarized how in this case, the district court used several factors to determine if a set of beliefs is religious. Generally speaking, the court looked for ultimate ideas, metaphysical belief, a moral or ethical system, comprehensiveness of belief, and accoutrement of religion, including founder, important writings, a gathering space, keepers of knowledge, ceremonies and rituals, structure or organization, holidays, fasting or diet, appearance, and clothing and propagation. Lake quoted the district court, which wrote, "No one of these factors is dispositive, and that they should be seen as a criteria that, if minimally satisfied, counsel the inclusion of beliefs within the term religion." In addition to the criteria outlined in Myers' case, Lake also contends that the court takes a functional approach to defining religion. To identify this approach, he cites the 1965 case United States v. Seeger, where the Supreme Court analyzed, and this is very circular logic, to determine if something was religion, the Supreme Court analyzed whether the beliefs professed are sincerely held and whether they are, in a claimant's own scheme of things, religious. Religious beliefs, the court argues, are those that stem from a person's moral, ethical, or religious beliefs about what is right and wrong and are held within the strength of traditional religious convictions. Lake calls this the functional approach to defining religion, and he concludes that this approach is more forgiving in the sense that what might not qualify as religion under Myers could qualify under the functional approach. In short, Lake contends that while the courts and government more broadly have never provided a clear summary of the criteria they will use to evaluate religious beliefs and the religious sincerity of entheogenic communities, the two ayahuasca cases, combined with the factors outlined in Myers and Seeger, provide a roadmap of sorts for future entheogenic communities. Based on this information, Lake created what he called the General Guide to Forming a Nonprofit Church. In this guide, Lake discourages religious innovation as he instructs entheogenic leaders to replicate existing precedent. To this end, he encourages his clients to form legal churches in the state where they will operate. He provides a rather detailed how-to guide of sorts, where he recognizes that while each state is potentially unique, states generally require churches to have boards of directors, a registered agent, and several other components. He instructs his clients to create bylaws, and most importantly, he instructs his clients to include a statement of belief with accoutrement clauses where the client specifically references many of the factors from the Meyer test as possible. For many people, the decisions and criteria outlined in court decisions and summarized by Lake seem reasonable and even expected. After all, ultimate ideas, metaphysical beliefs, a moral and ethical system, comprehensiveness of beliefs, these are common aspects of what many identify with religion in the United States. Entheogenic practitioners, however, identify several major problems with this assumption. First, as scholars have argued, dominant notions of religion and religiosity tend to reflect the nation's Protestant, or more broadly, Christian majority. From this perspective, legal assumptions based on Christian organizational and metaphysical models normalize, naturalize, legislate, and impose artificial and arbitrary organizational and ideological boundaries on groups and communities who, in their ideal worlds, would have substantially different models of organization and belief. These models include various models from indigenous practitioners, models that don't replicate or are not based on institutional religiosity commonly associated with Christianity. In other words, models of religiosity that deviate from the Christian mold. Entheogenic practitioners also feel constricted by case law and precedent that requires the entheogenic sacrament to be, in the words of another entheogenic attorney, Gary Smith, at the dead center of your religion. To understand Smith's point, consider that in the UDV and Church and the Santo Daime case, the courts only granted these groups an exemption from prohibition because the consumption of ayahuasca was an essential component of their religion. If the courts prevented them from consuming ayahuasca, they would substantially burden the groups by preventing them from practicing their religion at all. Entheogenic practitioners, however, remind us that different models of entheogenic consumption do exist, and those that don't place the consumption of entheogens at the center of their beliefs and practices. In this regard, government policies have resulted in in groups elevating the status of so-called drugs. In short, this truncated analysis reveals that the government has claimed authority over both the laws that govern the use of entheogens and over the ability of people to use these substances free from threat of prohibition. In other words, the underground, that is, the space of behaviors that challenge governmental authority, is created by the government itself. As demonstrated by countries that allow people to use these substances legally, the underground is not a natural or organic space. It is, however, the space the government creates when it assumes authority over the lives of its citizens and subsequently exercises this authority. In conclusion, history simultaneously demonstrates, first, that the US government does not intend to surrender this authority. Second, that more Americans are increasingly consuming entheogens, or what the government considers illegal drugs. History has also demonstrated that the state continues to be the primary curator of the entheogenic underground, first, by creating laws that limit the sacramental consumption of these substances. Second, by motivating communities to operate deeper in the underground where they hope to escape the government's attention. Third, by encouraging people to place drugs, quote unquote, at the center of their religions. And fourth, by motivating Americans to replicate models of entheogenic religiosity, models that do not seem natural to them, but models that practitioners hope will help shield them from legal persecution and prosecution. History has yet to tell us if these Americans will be allowed to emerge from the underground. If they do, however, it will only result from the state's loosened grip on what is an increasingly common form of religion. Thank you.
Many thanks to Brad for his fascinating presentation. Next up, let's welcome Tarryl Janik, who received his PhD in anthropology from the University of Wisconsin-Milwaukee. He'll be presenting Soul Quest Ayahuasca Church of Mother Earth versus the DEA.
Good afternoon, everybody. How many of you in here have heard of Soul Quest Ayahuasca Church of Mother Earth before? So my paper is going to build off of the last two presentations, and hopefully you'll see that connection, and we'll have a really fascinating discussion about religion and law today. And so Soul Quest Ayahuasca Church of Mother Earth, Soul Quest, was founded by Chris and Verena Young in Orlando, Florida in 2015, and is located on a small parcel of property on the outskirts of the city. There are typically over 50 people who show up for ayahuasca ceremonies every weekend at Soul Quest, many of whom end up becoming volunteers or members at the church. After attending ceremonies, many church members attend virtual integration sessions, which are offered by the church to help members integrate their ayahuasca experiences into their daily lives. I've been doing ethnographic research at Soul Quest and within these virtual integration sessions since 2019. Not long after opening, Soul Quest created a website on an online presence on Facebook, advertising their ayahuasca retreats to the public. This caught the attention of the DEA, who then contacted Soul Quest and directed them to apply for a religious exemption under the Controlled Substances Act of 1970, the CSA 1970. Soul Quest complied. For the 3 years, they waited for a response. In fear that the DEA was disingenuous for telling them to apply for religious exemption and that they may be criminally charged for illegally importing and using ayahuasca, Soul Quest filed suit against the DEA in the Middle District Court of Florida. Their hope was to initiate a DEA response to the religious exemption application, but during this time period, the COVID-19 pandemic was ongoing, and DEA agents found themselves short-staffed. Due to these circumstances, the DEA asked the court for a, quote, stay of proceedings so that they could work with Soul Quest to determine proper protocols for legally importing, storing, and handling their ayahuasca in accordance with the CSA. It was throughout the stay of proceedings that the DEA investigated Soul Quest on site and through interviews before sending their letter of final determination, which denied Soul Quest religious exemption for a lack of religious sincerity. After Soul Quest was ordered by the DEA to apply for exemption, to which they were primarily denied in 2021 for a lack of religious sincerity. Their lawsuit was dismissed by the Florida Middle District Court for wrongful jurisdiction. SoulQuest then appealed to the 11th Circuit Court, who in a 2-to-1 majority upheld the state's verdict, saying that the complaint over the DEA's denial of religious exemption was appropriately dismissed by the Middle District Court, and that the exemption case does not fall under the RFRA, or Religious Freedom Restoration Act of 1993. In response, SoulQuest has petitioned the 11th District Court for en banc rehearing, arguing that the majority made a precedent-setting error and that the panel opinion's errors, quote, imposed dangerous effects upon appellants' RFRA safeguarded sincere religious beliefs, end quote. Given this, SoulQuest still holds ayahuasca ceremonies. Two important questions that arise out of the case between SoulQuest and the DEA are, one, how does the state interpret sincerity of religious belief? And two, how does SoulQuest perform churchness to convince the state that they are sincere church in law, worthy to be granted religious exemption? To date, there are 2 American ayahuasca churches that have been granted some degree of religious exemption, Santo Daime and União do Vegetal, both of whom were found to be sincere in their religious belief by the state in law. This is also primarily due to both of their indigenous connections to Amazonia. No other American churches have successfully been granted religious exemption for ayahuasca use, although there are a few that are currently seeking it, such as the Arizona Yage Assembly, Ayahuasca Healings, the Church of the Celestial Heart, and SoulQuest.
Condor.
And Eagle and Condor. Winifred Fowler Sullivan, 2020, has argued that sincere belief for the state is informed and shaped by the notion of what she calls the church in law, or a church-state mimesis taking place. Sullivan states that, quote, American law has shown that it cannot think religion without the church. That space for religion in US law is a church-shaped space, end quote, which is largely, although not exclusively, indebted theologically and phenomenologically to Protestant reflection and culture. This broader ongoing historical problem of the church in law is part and parcel to Sullivan's notion of the impossibility of religious freedom for otherwise religion like SoulQuest, who are having to conform to the notion of the church in law when it comes to performing religious sincerity to the state. For SoulQuest, sincere belief is intimately intertwined in the subjective experience of the plant ayahuasca. Ayahuasca is an extremely personal and subjective experience. Not everyone who uses it has the same experience, nor does it affect everyone in the same way. SoulQuest seeks to institutionally formalize their beliefs by gaining religious exemption, but that's at the center of this struggle is the state's own perception as to what sincerely held religious belief looks like, which is based in the notion of the church in law in the sincerity test of United States versus Ballard, 1944. For SoulQuest, the difficulty in demonstrating churchness to the state is because the plant is the church. And so we see 2 very different worldviews collide, each of which is trying to define what religion is in law, one centered upon the church in law and another around the phenomenology and ontology of a plant, ayahuasca. In this dynamic engagement between church and state, we see a number of ways that SoulQuest situationally adjusts themselves to the DEA to perform churchness in law to convince the state that it is sincerely religious. Over the course of 4 years, I've paid close attention to the process in which SoulQuest attempts to negotiate, demonstrate, and practice sincere religion while under the scrutiny and surveillance of the state. By conducting qualitative ethnographic research at SoulQuest, where the ceremonies take place, sitting in on Zoom integration sessions, and performing exegesis of the ongoing court case between the state and SoulQuest, it was clear that SoulQuest was consistently compelled to make a series of situational adjustments to their practices and front-facing self-presentation in order to perform churchness, which the DEA ultimately read as insincere and was their principal reason for denying them exemption in 2021. One of the central arguments used by the DEA to show SoulQuest's lack of religious sincerity focused on the significance of the Ayahuasca Manifesto to church members, an online manuscript which SoulQuest identifies as its, quote, sacred text. SoulQuest refers to the manifesto in church services, Zoom integration, and ceremonies. They do read from it regularly and draw from it as a claim to their rights to use ayahuasca. In the interviews with church members, the DEA claimed that the manifesto only came up in conversation a couple of times, and that most members did not even mention it at all. It was because of this that the DEA was not convinced that the manifesto was SoulQuest's sacred text. This lack of engagement with the manifesto by church members is something that SoulQuest counter-argued in a variety of contexts in law and Zoom integration. They created specific integration groups focused upon the manifesto to both prove to the DEA that they were sincere in their belief and that church members did engage with the text as a sacred text. They felt obligated to show that they had a sacred text to the DEA to conform to the notion of the church in law. They're also advised in many ways by their legal counsel, who are also adjusting their own methodology for litigation based upon the notion of the church in law. Because of this, SoulQuest had to emphasize things that were not central to shamanic practices, but instead try to meet the expectations and standards of the law for what makes a religion. SoulQuest made the same mistake that many entheogenic churches have also made with the DEA, specifically having to describe themselves in ways that they were performing for the state and not actually representative of the church. At the same time, the DEA was also having to situationally adjust their approach to the case when they made SoulQuest apply for exemption to the CSA in 1970, not RFRA 93, and perform like a church in law while elucidate in court that SoulQuest never mentioned the ayahuasca manifesto in official interviews. The DEA's sincerity proof was also premised on demonstrating SoulQuest's efforts to attain religious protection without having to apply for exemption from the DEA by associating itself early on with the Oklavaya Native American Church, the ONAC, a church that claims to be both native and protective in their use of entheogens in the US, but is neither. Once SoulQuest realizes this, they quickly disassociated themselves with the ONAC, but this too the DEA saw as insincere in practice and used as a mark against them in their final determination. Finally, the DEA likewise had a problem with how SoulQuest church leaders described ayahuasca as therapy and not sacrament. One such leader says, quote, ayahuasca is 5, 15, or 20 years of psychotherapy in a weekend, end quote. The DEA found the ongoing emphasis placed on psychotherapy at SoulQuest insincere and not religious. This is because the DEA based their notion of a church on Sullivan's church in law, not a model of psychotherapy. The DEA also argued, quote, SoulQuest's website and public advertisements also do not support the claim that SoulQuest offers ayahuasca solely for religious purposes and only to members who are exercising religion pursuant to a sincerely held religious belief, end quote. Here the DEA claims that what SoulQuest says and does are two very different things. Well, on the one hand, SoulQuest incorporated as a nonprofit church, but on the other, they are advertising for-profit services through their healing center online, which the DEA also thought was quite insincere. The SoulQuest case is an inflection point in an enduring story about religious freedom and sincerity in America, which traces its historicity to the 1940s when the courts were broadening their notion of religious freedom and when sincere belief became the standard for defining religion. This ultimately led to what Sullivan, McCrary 2022, and others have observed as a model of Protestantism in law that many judges depend on to determine religious sincerity, as we've been talking about today. Sullivan, Spencer Dew 2019, and McCrary 2022 have shown that religious freedom is an entangled concept that intersects with issues of race, class, and power in the United States. Their work also directs our attention to new ways for thinking outside of the framework of Sullivan's church in law, to incorporate otherwise or alternative, and in this case, underground psychedelic spirituality and religion. In a 2021 symposium of essays that engaged Sullivan's book, Church-State Corporation, Joshua Maldin argued that, quote, courts get involved in religion because religion goes to the courts, end quote. This point is worth reflecting upon. SoulQuest went to the courts because it's only through law that individuals employ and enhance their agency and sovereignty when interacting with the state. One can only gain religious freedom of religion by going to law, especially when the law comes to you first, as is the case with SoulQuest. And as Spencer Dew 2019 shows, individuals situationally adjust themselves to the state in law and on the streets as a survival strategy, where they, quote, seek protection from the power of the state through appeal and to inclusion with the state, end quote. The strategy has seemed to work out well for SoulQuest, who has continued to host ayahuasca ceremonies during the liminal process of litigation with the DEA. SoulQuest is even expanding and building another church in Texas. Spencer Dew 2019 also argues this kind of engagement with law is a sovereignty issue that is made visible through state encounter, police, judges, lawyers, etc., just as in the psychedelic justice movement, where exemplars like military veterans and court cases like Church of the Holy Light of the Queen versus Marinacci 2009 and Gonzalez versus Ocentro 2006 serve as symbols of and cultural scripts for future action. It illustrates how Aliyit performances in law and everyday life become instructive in purpose when dealing with the state about religion. We see this happening as well with numerous psychedelic justice advocacy groups like Chacruna, who seek to aid and inform individuals on dealing with the state when it comes to psychedelic religion. But even if individuals can tactically engage the state to empower themselves by going to law, can there ever be an alternative to the paradigmatic state and church, or church and state encounter? Sullivan's 2020 answer to this question, Spencer Dew calls a revolution through encounter. Sullivan envisions a religious community outside the political and legal framework of the state. She imagines opposing parties coming together at a shared table. But what would this new encounter and this shared table look like? For Sullivan, it's analogous to the famous meeting between the late celebrity chef Anthony Bourdain and Barack Obama. Sullivan describes the scene as a crowded table where they partake in beer and noodles in Hanoi, where, quote, various otherwise opponents or exemplars of counter communities gathered together, end quote, practicing what she recognizes as, quote, the hospitality and table fellowship that all religions teach, end quote. This communal table for Sullivan is about disestablishment, not establishment. It is instead centered upon the freedom of speech and religion, the exchange of ideas, and a paradigm shift in our legal system when it comes to thinking religion. This project of disestablishment for Sullivan is what Spencer Dew conceptualizes as a community beyond the framework of the state, predicated on exchange and encounter and change. A model where religion is beyond definition and sincerity is not put to any sort of test. This alternative model is instructive in the case of SoulQuest versus the DEA for thinking about how the secular is shaping the religious and the religious is influencing the secular. In the case of SoulQuest, a secular incorporated institution seeking religious exemption versus the DEA, a secular institution, secularism may just be Sullivan's shared table, a possible venue for the state and the plant, ayahuasca, to have a dynamic encounter to rethink religion. Thank you.
Thank you very much, Tarryl Janik, for your presentation. I'd now like to welcome our final presenter, Mike Marinacci, who is an independent scholar and author of Psychedelic Cults and Outlaw Churches, California Jesus and Mysterious California. Please welcome Mike.
Well, folks, you have heard an excellent legal analysis of the issue of psychedelic religion and two very incisive academic presentations. Now you're going to get the pop sociology, pop history version from me. Okay. My most recent book is Psychedelic Cults and Outlaw Churches, LSD, Cannabis, and Spiritual Sacraments in Underground America, published by Park Street Press. It is a popular history and study of modern North American religious groups that use entheogens in their spiritual practices. Other than Dr. Laurie Kosad's God on High, it is the only monograph on this topic of which I am aware. My talk will be a basic overview of this religious and cultural phenomenon. Psychedelics and their ability to awaken heightened states of consciousness have been a fascination of mine since my university days. In the mid-'80s, I became aware of an underground network of religious groups dedicated to the use of these mostly illegal substances as sacraments, and I reached out to several of them. Unfortunately, most of these sects were either defunct or hiding from legal persecution, so information was often hard to obtain. As the so-called war on drugs began to ease up during the 90s, entheogenic religion gradually emerged from the cultural shadows. During this era, I spoke extensively with leading figures from the entheogenic spirituality world and began to collect data about them from primary and secondary sources. Much of the material was obtained from both ephemeral works published by these groups in the so-called zine culture of the era and from specialized library collections. In recent years, the internet has provided much more data via online periodical and academic archives, as well as these groups' own websites. As a result of my research in a variety of sources, much of the information presented in the book has never appeared in any other academic or popular books about entheogens. My study of psychedelic religion in modern North America begins with Native American peyotism. Although Paleolithic era evidence of the cactus's use has been found in Texas's Rio Grande Valley, American peyotism emerged in modern times in the wake of the 1890 Ghost Dance Rebellion, when indigenous resistance leaders John Wilson and Quanah Parker promoted the visionary and healing use of the plant among American Indian tribes. They developed formal rituals to accompany its use, and when these practices spread among Native Americans, government authorities began a century-long campaign of persecution against peyotists. In 1918, the Native American Church was incorporated in Oklahoma to provide legal protection for the various peyotist communities on First Amendment freedom of religion grounds. Nevertheless, the persecution of peyotists continued, and for the rest of the century, the church, which eventually grew to number between 250 and 500,000 members, fought in state and federal courts to protect its communicants' rights to consume peyote as a sacrament. In 1994, the American Indian Religious Freedom Act amendments were passed by Congress and signed into law. They guaranteed that church members who could prove they were of at least 1/4 indigenous descent could legally participate in peyote rites. 2 years later, Canada carved out a similar exemption for First Nations peyotism in its drug laws. Non-indigenous peyote-using spiritual groups have been less successful in obtaining legal and social recognition. In the 20s, Oklahoma's Church of the Firstborn spread peyotism to the state's African-American population, but it vanished after the founder was murdered. The New Mexico-based Church of the Awakening, founded in 1963 by 2 retired white osteopaths, spent a decade promoting peyote use as a spiritual path until the U.S. Ninth Circuit Court ruled that it wasn't a legitimate religion. The Arizona-based Pan-Ethnic Peyote Way Church of God's practices are currently tolerated in several Western states, but still lack federally approved status. And the Oklaveha Native American Church, which not only admits non-indigenous people, but recognizes cannabis, ayahuasca, psilocybin, and other organic entheogens as sacraments, continues to court controversy in both legal and indigenous spiritual circles alike. While Native American peyotists fought the courts for the right to consume the cactus sacrament, a different form of entheogenic spirituality emerged in non-indigenous, post-war North America. Inspired by Aldous Huxley's accounts of mescaline journeys, as well as the beat and hippie counterculture's social and spiritual experimentations, a new subculture appeared that scandalized mainstream America with its advocacy of the psychedelics as the chemical key to spiritual gnosis. Chief among the substances embraced by this generation of inner space explorers was lysergic acid diethylamide, a powerful hallucinogen first widely used by intelligence agencies as a potential psychological war weapon against communism. In the early 60s, 2 Harvard psychologists, Timothy Leary and Richard Alpert, discovered the life-changing power of the chemical, left academia to promote its use, and settled in an upstate New York estate owned by 2 scions of the Mellon family and known as Millbrook. For the next 5 years, Millbrook would be the East Coast center of the American psychedelic revolution. So closely was the LSD experience identified with spiritual awakening among users there and elsewhere that Leary produced translations of 2 classic Eastern religious texts designed to aid trippers through their otherworldly and sometimes terrifying visions. And those texts are the Psychedelic Experience, which is based on the Tibetan Book of the Dead, and Psychedelic Prayers to the Tao Te Ching. Leary also abandoned his earlier promotion of LSD as a revolutionary therapeutic agent and proclaimed it a religious sacrament, organized the League for Spiritual Discovery as the acid users' answer to the Native American Church, and worked to obtain the same First Amendment protections for the chemical that the peyotists claim for their plant Eucharist. Leary and the League shared space at Millbrook with a church that took a somewhat different approach to the psychedelic experience. Psychologist Art Klepps, who had first tripped on mescaline in 1960, formed the Neo-American Church in upstate New York 5 years later, relocating to Millbrook in early 1967. Klepps, who playfully dubbed himself and his followers boohoos, promoted a philosophy and theology he called solipsistic nihilism, maintaining that, quote, life is a dream and the externality of relations an illusion, end quote, and that the use of entheogens was the path to this realization. Pressured by external and internal troubles, the Millbrook Acid Commune collapsed in early 1968. Leary sought refuge in Southern California with the Brotherhood of Eternal Love, former street gangsters who had experienced lysergic satori and vowed to enlighten humanity with LSD, eventually distributing millions of doses across the globe. Another California sect, Shiva Lila, spent the 70s as a roaming hippie tribe using acid and tantric practices to simulate the innocence and immediacy of childhood consciousness. As with the non-Indian peyotists, the LSD churches found little sympathy from either the courts or public opinion when they could proclaim their rights as First Amendment-protected religious expressions. One California-based psychedelic sect, the Church of the Tree of Life, outflanked drug prohibitions by declaring such legal entheogens as lysergic-bearing morning glory seeds and mescaline-rich San Pedro cactus as their sacraments. In New York City, the Temple of the True Inner Light storefront church offered the legal psychedelic tryptamine DPT to visitors. And in British Columbia, the fane of the psilocybe mushroom adapted as its Eucharist the psychoactive fungi introduced to the West by Mexican shaman Maria Sabina. The ostensible legality and relative obscurity of these substances during the late 20th century shielded these small but influential sects from many of the troubles experienced by the LSD and peyotist groups. For many adherents of psychoactive spirituality, cannabis was their sacrament of choice. Followers of the Hindu god Shiva have honored him for millennia by ritually consuming cannabis. Their practices inspired San Francisco's Shiva Fellowship, which staged large public smoke-ins at Golden Gate Park in the late 60s until leader Willie Minzy was imprisoned. The fellowship transmogrified into the Psychedelic Venus Church, an early neo-pagan circle that celebrated the goddess in ceremonies that featured cannabis smoking, ritual nudity, and sacred group sex. In the 70s, reggae music introduced the world to a new religion that considered cannabis a sacrament. Known as Rastafarianism, it emerged in Jamaica as an Afrocentric, Bible-based sect that viewed Ethiopian Emperor Haile Selassie as a divine figure and ganja as the Eucharist that allowed the faithful to see through the deceptions of white Western Babylon. Although born of the African diaspora community, Rastafarianism produced a noted multiracial sect in North America, the Ethiopian Zion Coptic Church. Financed by a massive cannabis smuggling operation centered in Florida, the church was profiled in a national TV news stories and shortly thereafter taken down by federal drug agents. As in other cases, the courts were unconvinced by its members' First Amendment-based defenses. By the 21st century, North American popular opinion had warmed to the idea that cannabis had legitimate medical and spiritual applications. With increasing mainstream tolerance and relaxing laws regarding cannabis use, high-profile cannabis churches emerged across the USA. In Hawaii, Roger Christie founded the THC ministry to promote the healing powers of the plant and spent 4 years in federal detention when he ran afoul of the DEA. In Indiana, punk rock promoter Bill Levin took over an abandoned church and formed the first church of cannabis, challenging the state's prohibition laws and serving meals to the local homeless community. In Rhode Island, the Healing Church melded Roman Catholic apostolate work with public cannabis rights. And in weed-friendly Colorado, former pro athlete and entrepreneur Steve Burke's International Church of Cannabis hosted both regular sacramental services and a tourist-frequented light show in a colorfully painted historic stone church building. And you can see the interior of the church building in the upper left picture there. Perhaps the most dramatic aspect of modern North American entheogenic spirituality has been the rise of ayahuasca, a brew of psychoactive plants traditionally used by South American indigenous peoples for visionary journeys. Ayahuasca was popularized in the writings of Dennis and Terence McKenna, and countless 21st century psychedelic pilgrims have ventured to Peru, Bolivia, and other nations to legally experience the intense and life-changing effects of the potion. As with other entheogenic sects, the North American ayahuasca groups have struggled to be recognized and tolerated here. Canadian Trinity de Guzman attempted to hold his ayahuasca healings retreats in Washington state, but when controversies and legal problems dogged his efforts, he relocated the sessions to Latin America. Although courts have ruled that Brazil-based ayahuasca churches like, and I'm going to butcher the Portuguese here, I'm sure, the União do Vegetal and Santo Daime can legally practice their entheogenic rites here, homegrown sects like Florida's Soul Quest Church and Arizona's Yahweh Assembly still battle the DEA and local law agencies on First Amendment grounds. Like peyote before it, ayahuasca remains an illegal gray area for North American spiritual trippers. Another indigenous sacrament, the psilocybin mushroom, has found more favor on the American spiritual and legal scene, perhaps because of its growing acceptance as a psychotherapeutic agent. Psilocybin sects like Oakland's Zydor Church and San Francisco's Living Church openly distribute doses to their members, taking advantage of local laws that have decriminalized the entheogen. And in Utah, former Mormon state legislator Steve Urquhart's Divine Assembly holds well-attended psilocybin retreats, untroubled by the legal opprobrium endured by earlier psychedelic churches. Barring a prohibitionist backlash, it seems likely that entheogenic sects will continue to move towards religious and legal acceptability in North America. Courts are increasingly open to First Amendment arguments presented by the psychedelic churches, and the growing use of psilocybin and other hitherto prohibited substances in therapeutic work attests to their potential healing powers and supports the legitimacy of spiritual communities dedicated to their use. The religious movement that began among peyote-using Amerindians has now crossed racial and religious borders and embraces a diverse variety of entheogens, beliefs, and practices. And it will be fertile territory for continued research by students of psychopharmacology, comparative religion, and social phenomena. Thank you.
Thank you so much, Mike, Tarryl, Brad, and Allison. I'd now like to invite the audience to ask questions.
I think this question is for Allison, but if anybody else wants to take it. So you mentioned Smith, the Smith case. And what I've noticed is there's this sort of ooching of what we used to think of as fundamental and inalienable rights into something we now call civil rights. And it started with, I guess, the Civil Rights Act, and it was all wrapped up in, look, we're helping people and freeing them. But by the time you got to RFRA, it was, because if you think about it, Smith wanted unemployment. Getting money from the government is a civil right. But the Catholic Church putting cannabis chrism oil on a baby at baptism in their own place, that's a fundamental, inalienable right. Right. So RFRA, I don't see it now. RFRA applies. They have all these new tests. And the overall effect has been to reduce and eliminate, because we've moved from an American model of inalienable rights to a British model of the House of Lords grants rights, because what they grant, they could take away. So how do you as a lawyer think you could make that distinction in the courts? Because Smith shouldn't apply to like the case of the Healing Church or a bishop in the cathedral at the Chrism Mass making a mixture of hash and olive oil and distributing to the priest to take to all the parishes. That's manufacturing and distributing. Nobody ever has thought to interrupt that, right? Catholic Church, like
Could
you
you
said. So my question is,
thank you.
how, because here all these cases are relying on civil rights and RFRA, how do you move the goalpost back to where it started, which was fundamental, inalienable rights, and government get on your side of the wall?
Yep. I guess I don't interpret it that way. I still see it as the fundamental right of religion. Where it was applied in Smith, which, by the way, is now irrelevant because of RFRA, in that case, the issue was their use of peyote. That's what disqualified them from receiving those unemployment benefits. But the issue there was the exercise of religion, which is a fundamental right. No, and so what's interesting is that we are seeing, Soul Quest where they were required to submit to the DEA in their application process and received a denial letter saying they are not a religion, they are not a church. They continue to operate. I'm part of the Chacruna Council for Protection of Sacred Plants. One day we decided to see how many psychedelic churches we could find on Instagram, and it was a lot. So what's interesting is to see that a lot of it isn't really being prosecuted at this time. I think there is concern about additional precedent set. I helped in the representation of what he self-proclaimed as the mushroom rabbi in Colorado. Those charges were dropped. What we're seeing is less prosecution because I think of the fear of the expansion of the right of religion in the courts.
Counsel, if I may add a little,
Please.
to me, lawyers are always counsel. A little footnote to that: Smith, in the Smith case, was a drug recovery, drug abuse counselor.
That's true.
And I think the nut of the case really came from that it was seen as a conflict of interest that he was attending peyote ceremonies.
Yes. So they were fired because of a drug test where they were counselors for people who were addicted to drugs, but they were engaged in sincere ceremonial use of peyote within their Native American church. So that was a whole hypocrisy there.
They were also guilty of being Native Americans. So just naming, I mean, you're right, in the eyes of the law. We can't pretend that didn't
Yes,
factor into
we
it.
know the drug war
Right,
has
right.
Yep.
significant their civil rights being an issue, and obviously racism, big topic.
Yeah, and that led to what I mentioned, the American Indian Religious Freedom Restoration amendments to RFRA,
True, 'cause-
which said cut forever if you can trace your ancestry at least 1/4 to registered American Indian nations and are in a recognized Native American church ceremony, it's okay. We aren't going to bust you. We'll just look the other way.
right. RFRA was 1993, and the Native American
The year
peyote
after.
exemption was
Yes.
94.
Yes.
And what's interesting is even states have some version of the peyote exemption that's even broader and says that any bona fide religious use of peyote is exempt without even mentioning Native Americans. And I think it's because of this concern of preferring one religion over another, which is illegal. But of course, then there's appropriation concerns, obviously.
And with that, we unfortunately do not have any more time for questions. Please join me in thanking the Underground One panel.
Sponsor, Center for the Study of World Religions.
Copyright 2024, the President and Fellows of Harvard College.